bodies, other official bodies, and NGOs. Everything I've said about the FFM reports applies equally, or with even greater force, to these bodies. I need not repeat myself to any great extent. These other bodies, like the FFM, did not have the expertise or resources or the mandate to produce materials suitable for use as evidence in judicial proceedings. They did not purport to apply the standard of proof applicable in this case. Any findings in such reports are not made by judges and are not made following any adversarial judicial process. They represent only one side of the story. They are secondary sources of information. They give second-hand summaries of events spoken of by those who the organizations interviewed, and second-hand descriptions of any documents that they considered, and express opinions which are not evidence. This court has no way of making its own independent determination of facts based on documents such as these. A representative of Amnesty International is reported as acknowledging, in respect of fact-finding by NGOs, that we're trying to get the facts, but they're not facts that have to stand up in a court of law. Despite this, the Gambia seeks to rely on such reports as if opinions stated in them are definitive proof of facts. I pointed out before that many of the IIMM witnesses have admitted to giving prior inconsistent statements to other organizations. Many of these witnesses sought to explain that prior inconsistent statements, tried to explain the reason for those prior inconsistent statements was the result of the way the earlier organizations interviewed them, saying that the interviews were brief, lacking in detail, with questions asked non-chronologically and statements not being read back to them. And this just underscores how these other organizations did not produce reports by a process that makes them fit for use for forensic purposes. In any event, not all of the reports and documents relied on by the Gambia even purport to be investigations into the facts. They vary in their level of detail. Some merely contain high-level statements that do not refer to any evidence or sources. These observations apply also to the analytical reports prepared by the IIMM. These also consist merely of descriptions and summaries of evidence said to be held by the IIMM and set out the IIMM's own analysis of this material and the IIMM's own conclusions based on this material. The Gambia effectively admits this. But conclusions and opinions carry no evidential weight. If the documents referred to in these analytical reports had all been annexed to the written pleadings or otherwise been put into evidence, the court could have examined them itself and formed its own view based on them. Little or no evidential weight can be given to second-hand or hearsay descriptions in the IIMM analytical reports of the contents of the documents cited in them. And again, it's astonishing that the IIMM would not have made all of the documents referred to in its analytical notes available to the parties for use in these proceedings, given that the mission of the IIMM is to produce and maintain evidence for use in judicial proceedings. The Gambia might have approached all the organizations producing all of these reports and asked them to share their documentation and evidence underlying the reports. Instead, it's just unquestioningly relied on the reports themselves. and this highlights just how little effort the Gambia has put into investigating this case. Mr. President, members of the Court, I turn now to another category of material relied on by the Gambia, which I refer to as records of interview. By this, I mean a document prepared by someone other than a witness that simply records what a witness is understood to have said. Such a document is not signed or adopted by the witness, who may not have read it and may not be aware of its contents. An example of this kind of document is the FFM record of interview that I took you to on Friday, that's at tab 6.2 of your folder from last Friday. As I observed on Friday, the court held in Croatia that this kind of document has no evidential weight. Other documents of this type relied on by the Gambia include the collated information document prepared by Legal Action Worldwide, the first-hand testimonies prepared by Fortify Rights, and a document provided by the International State Crimes Initiative at Queen Mary University of London. Screening notes, or notes of screening calls taken by the IIMM, also fall into this category. Such documents are only a preliminary step in the process leading to the preparation of a witness statement. They're not of themselves signed witness statements. And for the same reasons, no evidential weight can be given to these documents. Mr. President, members of the Court, another important matter is the issue of impartiality and neutrality, or the lack of neutrality and perceived lack of impartiality of some of the organisations producing the materials most heavily relied on by the Gambia. The Gambia states forcefully that the materials on which it relies have been produced by reputable international human rights organisations, by diverse and independent sources, by independent and authoritative non-judicial entities, by independent, impartial and authoritative third-party entities, by disinterested third parties, and by disinterested witnesses. In fact, some of the key organisations, even if institutionally independent of each other, do not appear to be neutral and unconnected parties in these proceedings at all. I've already mentioned that the witnesses giving the witness statements prepared by Legal Action Worldwide are all clients of that organisation, which is providing legal services to them in what is said to be their quest for justice and accountability. The purpose of preparing the Legal Action Worldwide witness statements is said by the Executive Director of Legal Action Worldwide to be to gather witness testimony evidencing the physical acts of genocide. Thus, the Legal Action Worldwide witnesses have given a specific mandate to that organisation to support a particular outcome in this case, rather than to investigate events neutrally and impartially. The witness statements prepared by Legal Action Worldwide then state that they've been prepared specifically for purposes of this case. That organisation made the witness statements and other materials available to the Gambia, but not to Myanmar. Legal Action Worldwide also works with an organisation called Justice Rapid Response, which provided some of the investigators who took some of the Legal Action Worldwide witness statements, although details of the relationship between the two organisations is not clear. What is known is that the Executive Director of Legal Action Worldwide is a rostered expert with Justice Rapid Response, as is the Gambia's expert witness, Professor Michael A. Newton. Justice Rapid Response and Legal Action Worldwide issued a joint press release stating that the two organizations have worked towards gathering evidence to support the case brought by the Gambia. It's furthermore noted that the Executive Director of Legal Action Worldwide formerly worked for the FFM. Legal Action Worldwide has also received support from the Government of Canada, which provided investigators from the Royal Canadian Mounted Police to take some of the witness statements prepared by Legal Action Worldwide. Canada has also issued a statement that its intervention in this case would support the efforts of the Gambia, which Canada says has taken the laudable step of bringing this case before the court. Canada, therefore, overtly sides with the Gambia. Myanmar's written pleadings highlight also other issues with the lack of neutrality of Legal Action Worldwide. Myanmar also does not accept the impartiality or neutrality of Fortify Rights. Mr. Smith of Fortify Rights is officially part of the Gambia's delegation at this hearing. The evidence in this case includes documents produced by Fortify Rights, a witness statement by Mr. Smith, an article authored by Mr. Smith, and a witness statement that was taken by Mr. Smith. The Burmese Rohingya Organisation UK, which is also represented on the delegation of the Gambia at this hearing, was one of the joint signatories of a document relied on by the Gambia and co-authored a document with Fortify Rights cited in another document relied on by the Gambia. Mr. Smith and Fortify Rights are thus, at the same time, witnesses and sources of evidence in the case, as well as official representatives of the applicant in the proceedings. That is wholly inconsistent with the claim that evidence from Fortify Rights should be treated as emanating from an independent source. And Myanmar's written pleadings also highlight other issues with its lack of neutrality. These matters were drawn to the court's attention just before the hearing, and I refer the court to what is stated in the letter of the agent of Myanmar to the court dated 11th of January 2026. As the agent for Myanmar expressed it in his opening statement, in this case, representatives of the Gambia, witnesses, and authors of reports relied on by the Gambia as evidence are all sitting on the same bench, and the evidence is not independent. As to the IIMM, I've already noted that Myanmar does not recognize it. It's certainly not the case, as the Gambia suggests, that Myanmar has waived any objection to reliance on IIMM witness statements. However, quite apart from this, there are objective reasons for concluding that the IIMM lacks impartiality and neutrality in this case. First, the head of the IIMM was prepared to be called as a witness by the Gambia in these proceedings. Ultimately, he did not testify orally, apparently because the Office of Legal Affairs in New York did not give him permission to do so. However, he provided an affidavit to the Gambia, which the Gambia filed in support of its case, and he has thus given testimony as a witness of the Gambia in these proceedings. You will find this affidavit at tab 2.2 of your folder. You will see that at paragraph 42, his affidavit says this: I have been informed that among the material shared by the mechanism with the parties to these proceedings and filed by the legal counsel for the Gambia in support of its memorial, there are 10 redacted witness statements of Rohingya witnesses. While these represent a small proportion of the mechanism's relevant evidence, and a small proportion of the evidence that the mechanism has shared with both parties to these proceedings, I am satisfied that they are broadly consistent and representative of the mechanism's other evidence from witnesses and other sources pertaining to these incidents. And I ask the question, why would the head of the IIMM state this in an affidavit for use in these proceedings? Presumably, the IIMM has given all relevant witness statements and other evidence to the Gambia. Given the stated mandate of the IIMM, it would be incomprehensible if it has not. So if the Gambia wanted to rely on all the witness statements or any other evidence provided to it by the IIMM, it could have annexed all of them to its written pleadings, and the court could have decided for itself whether or not they are all broadly consistent. It would appear that this affidavit is intended specifically to assist the Gambia by enabling it to say in these proceedings that all 42 witness statements and other relevant evidence provided or held by the IIMM are broadly consistent, despite the fact that the Gambia has only put a small amount of it into evidence. And of course, the expression broadly consistent is a very ambiguous term. A statement that said no more than that military operations took place in northern Rakhine State in 2016 and 2017 might be said to be broadly consistent with the witness statements that have been filed by the Gambia. Yet by using these two words, the head of the IIMM seems to be telling the court, you have no need to look for yourselves at all of the other witness statements or any of the other evidence that the Gambia has not filed in these proceedings, because you can just trust me, they say the same things as the ones that the Gambia did file. I submit that that is astonishing. It is a plain fact that the Gambia consciously chose to annex only 12 out of 42 witness statements provided by the IIMM. There's no rational reason why the Gambia would have omitted to annex any IIMM witness statement dealing with the very events in question if the witness statement was at all consistent with its case. This affidavit of the head of the IIMM thus appears to be specifically intended to assist the Gambia to paper over this problem, and it certainly does not appear neutral and impartial. Secondly, paragraphs 54 to 64 of this affidavit describe the contents of the IIMM analytical notes relied on by the Gambia, and in some cases express opinions on them. For instance, at paragraph 55, it describes the analytical notes as comprehensive and detailed. At paragraph 58, he points out what he considers to be the significance of one analytical note. At paragraph 60, he says what he finds notable in another. And at paragraph 62, he refers to findings in an analytical note. These paragraphs of his affidavit can obviously add nothing to the evidential weight of the analytical notes. The court can look at the analytical notes itself and decide for itself what weight they should be given, which I have argued is little or nothing. The head of the IIMM is a lawyer and must know that it's a matter for the court to form its own view. The fact that he nonetheless gives an affidavit seeking to bolster the significance of these analytical notes to the apparent advantage of the Gambia also appears inconsistent with neutrality. Thirdly, paragraph 48 of this affidavit says that there are targeted killings by organized armed groups in the camps in Bangladesh, but conspicuously omits to mention that one of the main such organized armed groups is ARSA. The omission to mention this is also inconsistent with the appearance of impartiality, since, as I've already said, this affidavit expressly claims at paragraph 46 that witnesses fear a risk from Myanmar, despite the lack of any objective evidence of such risk. And for these reasons, the position of Myanmar is that any evidential weight that might otherwise be given to any materials produced by the IIMM, Legal Action Worldwide, Fortify Rights, and certain other organizations is seriously diminished by the lack of impartiality or neutrality of these organizations. Mr. President, members of the Court, I turn then to the evidential weight of the witness statements on which the Gambia relies. Contrary to what the Gambia suggests, Myanmar does not take the position that witness statements taken by a party to the case or by someone overtly siding with the party to the case must necessarily be rejected out of hand. Rather, Myanmar asked the Court to apply its settled jurisprudence. The Court does not simply accept everything stated in a witness statement. The settled jurisprudence is that witness statements and affidavits are treated with caution. What weight such a document is given will depend on a consideration of various factors, including the form and circumstances in which it is made. As to the IIMM and Legal Action Worldwide witness statements, quite apart from and in addition to the fact that Myanmar does not recognize the IIMM, these should not be given any significant evidential weight, given first, the lack of neutrality of these organizations, second, the almost complete anonymity of the IIMM witness statements and the remaining significant anonymity of the Legal Action Worldwide witness statements. Third, the fact that the reasons for anonymity are not adequately justified. Fourth, the circumstance that the body of material relied on by the Gambia as a whole is overwhelmingly anonymous. Fifth, in the case of witnesses in camps in Bangladesh, the pervasive influence of ASA in the camps. Sixth, the fact that the witnesses in Bangladesh themselves cannot be considered to be disinterested. Mr. President, members of the Court, I need not speak in detail about the witness statements of persons other than those in the camps in Bangladesh. They are addressed in detail in Myanmar's written pleadings, to which the Gambia provides no substantive response. Christina Lamb and Alex Crawford and Neville Lazarus give hearsay evidence about what they were told by others in Bangladesh and Myanmar. Jonathan Head gives hearsay evidence of what he was told by others in Myanmar and expresses mere opinions on certain things he witnessed. None of these witnesses personally witnessed any atrocities being committed, nor did Andrew Riley, who gave one of the IIMM witness statements. The Gambia also claims to have evidence from a number of defectors or deserters from the military. However, this material also lacks evidential weight. Apart from anything else, it's not possible to know whether the claimed defectors are in fact the persons they claim to be, or whether they were actually in northern Rakhine State at the time of the events. Furthermore, military defectors will have some grievance with the military, and it cannot be assumed unquestioningly that the reasons stated by a defector for deserting from military service are true. In the case of an anonymous defector, the reasons for defection cannot be tested. The evidential deficiencies of the video interviews of two claimed deserters from the Tatmadaw and of other witnesses are also set out fully in the written pleadings. The witness statements, or parts of them, also lack evidential weight for other reasons recognised in the settled jurisprudence, including that they contain information that is or might be hearsay or opinion, and are made years after the event and after the institution of proceedings for purposes of the case. Mr. President, members of the Court, the Gambia avoids all serious discussion of issues of evidential weight and continues to assert simplistically that documents it relies on should be accepted as proof of whatever they say. It seems the Gambia simply received documents from third parties or took them from public sources and then unquestioningly and uncritically annexed them to its pleadings. There's no suggestion that the Gambia undertook investigations of its own or took steps to verify the accuracy, credibility, and reliability of the information in the material received from third parties. There's no suggestion that it sought to obtain from third parties the evidence underlying their reports or the identities of the persons they interviewed for purposes of verifying information. The Gambia effectively acknowledges that the third-party reports it relies on have even less evidential weight than the FFM reports. It acknowledges this by making the FFM reports the centrepiece of its case. It states openly that it does not rely on these other reports as its principal sources of evidence, but as material that corroborates and confirms the evidence contained in the two FFM reports. In a different context, but one in which a similar standard of proof applies, the International Criminal Court has held that NGO reports and press articles may be a useful introduction to the historical context, but that they do not usually constitute a valid substitute for the type of evidence that is required to meet the evidentiary threshold for the confirmation of charges. If they do not meet the threshold for confirmation of charges, a fortiori, they cannot meet the evidentiary threshold for a final judgment on the merits. As to the witness statements, when all relevant factors are considered, including the form and circumstances in which they were made, no evidential weight can be given to these either, or at least none that could come anywhere near meeting the standard of proof required for a finding of genocide in proceedings against a sovereign state. Mr. President, members of the Court, that concludes my presentation of Chapter 7. Mr. President, may I now invite you to call on Ms. Laurie, who will address the subject matter of Chapter 9 of Myanmar's written pleadings, namely the other locations.
I thank Mr. Staker for his statement. I now invite Ms. Lee Laurie to address the Court. You have the floor, Madam.
Mr. President, Madam Vice President, members of the Court, I follow on from Mr. Blom-Cooper's presentation on the three main locations to address 42 other locations where the Gambia alleges crimes were committed by Myanmar forces during counter-terrorism operations conducted in 2016 and 2017. My presentation relates to Chapter 9 of Myanmar's written pleadings. I'm going to start with an apology. My presentation is going to be detailed. It's going to be detailed because a case of this significance requires a rigorous forensic analysis of the evidence. A forensic exercise like this is more head than heart. By approaching the evidence in this analytical way, please don't think that we don't realise that the allegations in the speeches of the Gambia concern individual tragedies, unimaginable pain and suffering. But our role in these proceedings, on both sides of the bar, and for you, judges and finders of the fact, is to scrutinise the evidence, to ask hard, uncomfortable questions, to put the case to proof. Of course, the Gambia don't want to look at the detail. It seems to say that to ask questions about the evidence is disrespectful of victims. It denies their suffering. It is so analytical that it borders on the shameful. That by necessarily looking at the quantitative element, Myanmar is arguing that it is not genocide because it didn't kill that many. The Gambia ridicules Myanmar's careful approach, arguing it's akin to being stung to death by single bees. It may be, but the exercise is unfortunately absolutely necessary. Why does the Gambia ridicule scrutiny of their evidence? We are all lawyers, after all. The reason is simple. Their case doesn't stand up to the scrutiny required when invoking the Genocide Convention. The crux of the Gambia's case is that counter-terrorism operations conducted in 2016 and 2017 followed a consistent pattern, the same modus operandi, involving killing, extreme brutality and sexual violence in, quote, hundreds, unquote, of Bengali villages across northern Rakhine State. From this, it asks you to draw an inference of genocidal intent. If it cannot prove this alleged consistent pattern across hundreds of villages, little, if anything, remains of its claim of genocide. However, the evidence of this consistent pattern is just not there. The purpose of this forensic presentation is to explain why. Before getting into the detail, 4 headline points can be made. First, the Gambia can't even fix on the total number of locations it says form part of its pattern. Despite claiming that hundreds of villages were affected, the memorial focuses on just 3, the 3 main locations dealt with by Mr. Blom Cooper. According to Myanmar's analysis, the memorial discusses events at a further 38 locations, including Khao Sek, but it does so in an extremely generalised way. In its reply, the Gambia adds allegations for, in essence, another 4 locations, given that it confuses 2 different villages with the same name. In its oral submissions last week, it added another location not previously expressly mentioned, and that is Nha Yan Chong. Therefore, it appears the current total is 46 locations, not the claimed hundreds. As there were 509 locations in northern Rakhine State, which were either entirely or partially inhabited by Bengalis in August 2017, the Gambia is making allegations for less than 10% of Bengali inhabited settlements in northern Rakhine State. Second, the Gambia doesn't undertake the necessary analysis to support its claimed consistent pattern. It should be obvious that to demonstrate a consistent pattern, the evidence relating to each location must be examined individually. Once events in each location are established, they can then be compared and a judgment formed as to whether they show a pattern as between them. The Gambia does not do this. It also somewhat surprisingly argues that it is not required to do this. This argument is clearly wrong. To prove a pattern, some sort of repetition must be established among all locations said to form part of the pattern. Otherwise, a key finding in this case will be made by extrapolation alone. Third, by not properly specifying its case, many of the Gambia's claims are not properly anchored by an identified witness, a specific location, or by any date. I'm sure you remember the allegations of, quote, tongues and hands cut off, of hundreds of body parts hanging from trees, and of heads floating in the river like footballs. These come from two reports, one prepared by the Public International Law and Policy Group, PILPG, and the other prepared by the US State Department. As you will see on your screen, the sources of the first two allegations taken from the PILPG report are questionnaires. For the other allegation, taken from the US State Department report, no information is given about source. All we know is that the US investigators spoke to residents of camps in Bangladesh. This is the totality of the information we have to defend Myanmar in relation to these allegations. Now, they make for dramatic sound bites, but we are not here to consider sound bites. How does Myanmar, or indeed any state, positively challenge such vague allegations or call evidence to contradict them? It's impossible. Fourth, despite not bearing the burden of proof, it's Myanmar which undertakes the necessary analysis of the evidence. As has been explained in earlier presentations, Myanmar's general contention is that the material relied on by the Gambia can be given no or no significant evidential weight. Without prejudice to that position, Myanmar's detailed location-by-location analysis demonstrates additionally that this material does not show a consistent pattern of atrocities in the 46 locations. What this material shows is this. First, the operations were responsive. They responded to a specific threat posed by ARSA in and around each specific location. Second, the operations were focused. They were short-lived and only persisted for as long as necessary to neutralise the threat posed by ARSA. Therefore, if there was any pattern of conduct, it was one of responsive, targeted and time-limited action by Myanmar security forces, initiated only and in response to the undisputed violence of the terrorist organisation ARSA. As I've explained, the Gambia's allegations relate to a total of 46 locations. Mr. Blom-Cooper has addressed 3 of those in his presentation this morning. Khao Mon Sek was addressed in my presentation on ARSA on Friday. I will now address the remaining 42 locations in turn. My review of these locations will be broken up into 3 parts. The first will examine the evidence in relation to the 6 locations that were the subject of the specific examination by the FFM in its 2018 report. The second part will examine the 11 locations which only concern crimes allegedly committed in 2016. The third part will examine the remaining 25 locations mentioned in the Gambia's memorial, reply and oral submissions. The first location is Gu Dar Pien in Butidong Township. The evidence shows this. In August 2017, ARSA was present in this village, a fact conceded by the Gambia. There were only 2 consecutive days of counter-terrorism operations, all responding to ARSA's violence. The military first engaged with ARSA shortly before midnight on 26 August 2017, and again on 28 August when security forces came under attack from 500 ARSA terrorists. No evidence supports the Gambia's claim that all ARSA terrorists had left when the military was conducting its operations there. ARSA's violence in the area was not confined to Gu Dar Pien. On 27 August 2017, a warning about a possible ARSA attack on neighbouring Chok Sartain caused the predominantly Rakhine villagers to flee. Explosions were subsequently heard nearby, including in Tayet Tong, as was gunfire involving soldiers and armed Bengali. The available evidence contradicts the Gambia's case theory that the military was pursuing a pattern from which genocidal intent can be inferred. For example, the Gambia simply ignores 3 IIMM witnesses. P1548 says that in the aftermath of the August 2017 operations, villagers from neighbouring Pulkong Chang were detained by the military during a search for Gu Dar Pien residents and then released without incident after being warned against providing shelter to outsiders. His statement says, quote, "The military did not do anything to the Rohingya of Pulkong Chang, and there were many other Rohingya villages that were not harmed," unquote. Another individual, P0806, speaks about Bengali from Gu Dar Pien being arrested on suspicion of involvement in the October 2016 attacks, and of the presence of armed villagers and attacks on soldiers in August 2017. P1547 recounts that during her journey from Gu Dar Pien to Bangladesh, her group was stopped by the military without incident. No allegation that any sexual violence was committed in Gu Dar Pien is made in the memorial. The belated allegations made in the reply emanate from the FFM and Amnesty International, which lack evidential weight for the reasons already given. The two other sources relied on by the Gambia do not assist it. The incident described in Witness Statement 040 occurred at a location nearly 12 hours walk away, and the two incidents described by P1550 occurred before the counter-terrorism operations. They cannot be part of any purported pattern of conduct. Two further sources before the court undermine the claim that sexual violence was committed in Gudar Pien. P0806 states that he neither saw nor heard any accounts of the abduction or rape of women by the authorities. P1548 states that he did not witness or learn of any incidents of rape in Gudar Pien in August 2017, and admits he lied when he said in a previous interview that he had seen someone being raped there. In terms of the suspected death toll in 2017, the location had a Bengali population of some 6,300. The FFM suggests an unverified figure of 243 fatalities, while P0806 names 53 persons, overwhelmingly males, as having died. Other evidence records that approximately 15 people died during armed engagements. All these figures are a small proportion of the population. No indication is given in any of these estimates as to the numbers killed who were not taking part in the clashes. The second location is Alel Tenchio in Mongdao Township. The evidence shows this. In the early hours of 25 August 2017, ARSA launched 2 attacks on border guard police posts in the village tract. The attacks involved hundreds of terrorists and resulted in some 17 terrorists being killed, along with a deputy township immigration officer. No mention is made of this ARSA attack in the Gambia's memorial, or by 15 out of the 16 individuals whose alleged eyewitness accounts are relied on by the Gambia for this location, or in the solitary signed witness statement produced by the Gambia for this location. This undermines the credibility of these witnesses, since they cannot have been unaware of the ARSA attack or its materiality. There is no claim that sexual violence was committed in this location, a conclusion not contradicted by the FFM. In August 2017, the population of this village tract was some 11,500, the majority Bengali. The FFM mentions an unverified figure of up to 77 fatalities. No further detail as to the identity of or circumstances in which these persons were killed is provided. This figure is also a very small percentage of the population. The third location is Mien Hlut. The evidence shows this. At around 3 a.m. on 25 August 2017, ARSA attacked this location, killing 2 police officers. The security forces arrived later that morning, having been requested to attend to protect the local population from violence. No mention is made of this ARSA attack in the Gambia's memorial, or by the individuals whose alleged eyewitness accounts are relied on by the Gambia for this location, or in the solitary signed witness statement produced by the Gambia for this location. The Gambia's memorial makes no mention of sexual violence in Myanmar. In its reply, the Gambia relies on a passage from an FFM report quoted by Myanmar in its counter-memorial about a single hearsay allegation of rape. Whether or not that incident occurred, it is not the evidence of a pervasive pattern of genocidal sexual violence of the kind alleged by the Gambia. In August 2017, the population of the village tract was 16,837. The FFM mentions an unverified figure of up to 70 fatalities. Again, no further detail is provided, including whether any person was a civilian who had been deliberately targeted. Again, the figure constitutes a very small percentage of the population. The fourth location is Chok Pandu. The evidence shows this. In the early hours of 25 August 2017, ARSA attacked the border guard police camp in Chok Pandu. ARSA also destroyed a bridge at the location. In response, the military arrived on 28 August to reinforce the police outpost. They were later confronted by about 30 to 40 terrorists. None of this highly relevant context is mentioned by the Gambia or by the witnesses relied on by the FFM for this location. The only evidential source relied on for alleged killings and sexual violence at this location is the FFM. For the reasons already discussed, no evidential weight can be given to these anonymous, hearsay, untested summaries. The FFM mentions an unverified figure of 38 fatalities at this location. This is a very small percentage of a total population of 7,460. But the figure is of little evidential value when no information is given about the identities of the deceased. Were they police, terrorists, civilians, or the circumstances of their deaths? The fifth location comprises the neighbouring villages of Kotan Kok and Chain Kar Lee. The evidence shows this. ARSA activity in Kotan Kok goes back to at least 9 October 2016, when the police station was the target of one of 3 coordinated ARSA attacks on security forces across Rakhine State. This understandably resulted in an increased military presence in the area. Similar violence, but on a larger scale, occurred in 2017. Both Kotan Kok and Chain Kar Lee were the scene of repeated ARSA attacks between 25 and 28 August 2017, involving hundreds of armed terrorists confronting the military. These clashes were triggered by the simultaneous ARSA attacks on the border guard police station in both villages in the early hours of 25 August. This context is relevant to assessing material such as the FFM report, which states that in Chain Kar Lee, quote, many people were shot when fleeing. Given that the military were responding to an ARSA attack in this location, it is plausible that some of these people had been participating in the violence. But, like the FFM, the Gambia does not distinguish between ARSA and civilian casualties. The reality is that the evidence relied on by the Gambia for these 2 locations is not sufficient to discharge its high burden of proof. Save for one signed statement, It consists of anonymous, hearsay, untested, summary allegations. The solitary statement, signed 7 years after events and made specifically for these proceedings, is not sufficient either. Anonymity was lifted less than 2 months before these hearings, so late that no meaningful investigation could be undertaken, and it remains untested. The 2 allegations of rape noted by the FFM are also the product of anonymous hearsay. Even if this evidence were accepted without question, 2 isolated incidents in different villages clearly do not support the Gambia's claim of pervasive sexual violence. In August 2017, this village tract had a population of 10,492 Bengali. The FFM suggests an unverified figure of more than 180 fatalities, while Amnesty suggests at least 66 people died. No attempt is made by either source to identify whether any or all of the deceased were not legitimate targets. In any event, the figures amount to a very small percentage of the total population. The 6th location is Indin. The evidence shows this. On 25 August 2017, ARSA attacked police posts in 2 villages adjacent to Indin. The first attack occurred in Tinbokwai, a village to the north, at around 3:45 a.m. The second attack occurred in Tawin Chong, a village to the south, at about 4:50 a.m. 4 days later, on 29 August, 30 terrorists attacked Indin. Counter-terrorism operations were undertaken in response to these attacks. No mention of ARSA's activities in this area is made by the Gambia. Instead, it focuses on conduct which is undeniably criminal, but irrelevant to a claim of genocide. On 1 September 2017, 10 men were killed by Myanmar Defence Service personnel. Following an investigation, the Myanmar Defence Services admitted that its troops had been involved and that the rules of engagement had been broken. The clear motive behind the killing was identified as retribution for the murder of a local Rakhine man by Bengali. The available evidence therefore shows that this incident was not perpetrated with genocidal intent. The single allegation of rape for this location also doesn't fit the Gambia's narrative of pervasive sexual violence, nor do the number of suspected fatalities fit. Amnesty International suggests at least 17 fatalities, including the 10 killed on 1 September 2017. No indication is given as to whether the other 7 fatalities were the result of unlawful violence. Drawing my analysis of these locations to a close, the FFM considered that the 3 main locations plus these additional 6 locations were the most serious incidents. Yet none of them provide evidence of the Gambia's pattern. In relation to the 6 I have just analysed, there is no evidence of pervasive sexual violence. Specifically, no allegations of sexual violence are made for 1 location, and single allegations of rape are made for 4. I move now to analyse the 11 locations which only concern events in 2016. These are locations 7 to 17. Locations 7 and 8 are Doten and Nyakuya. Given their proximity, they're analysed together. The evidence shows this. On 9 October 2016, the police station in Nya Kuya was the target of one of the 3 coordinated ARSA attacks on security forces across Rakhine State. Events, especially those the following day, on 10 October, must fairly be considered against this background. They are clearly responsive rather than unprovoked. Do 10 and Nya Kuya feature once in the memorial. The material for Nya Kuya is a single sentence that an elderly woman was assaulted by soldiers. No date or further detail is provided. The material for Do 10 is similarly skeletal. An anonymous witness's account of being shot and their father being killed on 10 October. No explanation is given about how the father died or who killed him. It can be deduced that both allegations relate to 2016. Myanmar draws the court's attention to a purported sexual assault in Do 10 reported by the FFM, which also appears to date from 2016. This allegation relates solely to an invasive search for valuables. In its reply, the Gambia fails to mention Nya Kuya at all, whereas Do 10 is identified as a village that was, quote, completely destroyed. But no evidence is provided about when this destruction is said to have occurred or who was responsible. Taking this skeletal evidence at its highest, an assault, a single death, and an invasive search for valuables, it does not support the existence of a consistent pattern of conduct involving allegations of extreme brutality repeated throughout northern Rakhine State. The 9th location is Nya Sa Chu. This village is located close to Do 10 and Nya Kuya, and again only concerns crimes allegedly committed in 2016. The evidence shows this. An ARSA bomb-making factory was located in the village in 2016. On 7 October, an explosive device accidentally detonated in the village, causing ARSA to launch its attacks on 9 October, including in neighbouring Nya Kuya ahead of schedule. One allegation is made for Nya Sa Chu. It arises from an anonymous account in a February 2017 UN report that a house was burned, resulting in the death of a child who was left behind. No further information is provided, not even a date. The deficiencies in the value of this evidence are obvious. But even at its highest, this incident does not fit into the Gambia's claimed common modus operandi. This location is not mentioned at all by the Gambia in its reply. However, it was mentioned in the oral hearings last week as a location where women of reproductive age were targeted. Having checked the underlying material relied upon, this anonymous hearsay allegation was made by a witness from Nya Sa Chu, but relates to an incident in the next location to be considered, Chiet Yo Pien. The Gambia may dismiss this analysis as nitpicking, but identifying the correct location is important when what is at issue is determining whether a pattern covering various locations exists or not. The 10th location is Chiet Yo Pien, a village located to the south of Nya Sa Chu. The violence alleged by the Gambia for this village relates to activity by the military around 12 October 2016 and focuses mainly on sexual violence. Events in this village are tied to ARSA's activities on 7 and 9 October in the neighbouring villages of Nya Kuya and Nya Sarchu, which I have just described. Despite the relevance of these attacks to what subsequently occurred, no mention is made of them by the Gambia, nor, it would appear, by the individuals on who the Gambia relies. This omission affects their credibility. The evidence relied on by the Gambia for this location is exclusively untested, anonymous, hearsay summaries taken from UN and NGO reports. For the reasons already discussed, no evidential weight can be given to these sources. The Gambia also provides no evidence about fatalities. The reference to, quote, at least 20 dead bodies scattered in a field does not assist when it is not known if any of the dead were actively engaged in the ARSA attacks. In any event, 20 is a very small percentage of a total population of 8,259 in 2016. This is another location which is not mentioned at all in the Gambia's reply. The 11th location is Puen Phu Trong. The evidence shows this. Following the 9 October 2016 ARSA attacks, the FFM narrates that soldiers went to this village, quote, twice to look for bad people. On 11 November 2016, soldiers detained local men before releasing them. Later that day, local men were again detained and then taken to prison. Neither detentions nor the search for bad people fit with an intent to destroy. On 12 November 2016, the Myanmar Defence Services clashed with ARSA terrorists near Puen Phu Trong. One soldier was killed and several were wounded. 6 terrorists reportedly died. There is no mention of this relevant context by the Gambia. Serious allegations of killing, rape and burning are made in respect of this location, but the sources are exclusively untested, anonymous, hearsay summaries taken from the UN and NGO reports. For the reasons already discussed, no evidential weight can be given to these sources. The Gambia's reply contains no mention of Puen Phu Trong. The 12th location is Ushe Ja. This is another 2016-only location. The evidence shows this. In early September 2016, the identities of 8 local ARSA members were revealed to the police by 2 informers in Ushe Ja. The ARSA members were arrested on 12 September. On 30 September, ARSA reportedly killed the 2 informers, which led to police raids and arrests in the area. Absent this relevant context, the Gambia refers to only 2 incidents in this location. The first contains an anonymous allegation that on an undated occasion, soldiers rounded up elderly people outside a mosque and beat them. Omitted from the Gambia summary is that the soldiers were constantly asking, quote, "Where are you hiding weapons? Where are the armed insurgents? Show us the weapons or we will kill you all," unquote. Taking this allegation at its highest, it is clear from this fuller account that the securities forces were engaged in security operations directed at the threat posed by armed terrorists. The second allegation concerns an anonymous hearsay account of an assault on a pregnant woman by soldiers, resulting in a miscarriage. No further detail is provided. The source of this allegation is a woman from Usheja. It is unclear if the incident occurred there. The source for both allegations indicates that they relate to events in October or November 2016. The only other allegations for this location are identified by Myanmar and relate to what appear to be improper, inappropriate, invasive searches for valuables reported by the FFM and the UN, rather than the extreme sexual violence alleged by the Gambia. None of the allegations for this location support the existence of a common modus operandi. Location 13 is Myaw Tong. Given it is located a few kilometres away from locations 8, 9, 11 and 12, which I've just discussed, military operations in this location must be understood against the backdrop of the terrorist activity in the surrounding area in late 2016. Two anonymous witnesses alleged that they were raped in Myaw Tong. The allegations are contained in untested, anonymous, hearsay accounts given to a journalist and the UN. Neither account is corroborated. Neither account is dated, but the underlying sources indicate that they likely relate to autumn 2016. For the reasons already discussed, no evidential weight can be given to these sources. Not a single witness interviewed by the FFM refers to events in Myaw Tong, let alone to acts of unlawful homicide, physical assault, or sexual violence. Nothing at this location supports the contention that the Myanmar Defence Services were pursuing a consistent pattern of conduct, involving the same acts of brutality repeated in village after village. The weakness of the Gambia's allegations for this location is evidenced by the fact that its reply contains no mention of this location at all. The 14th location is Je Kak Trong Gua Song. The evidence shows this. Serious armed clashes between the Myanmar Defence Services and large numbers of ARSA terrorists and their supporters occurred in and around this location in November 2016. These clashes were linked to those in Puen Phu Chong as the attackers retreated to this village. During these attacks, several soldiers were shot, including at least one fatally. Je Kak Trong Gua Song was the scene of mass arrests of Bengali males in November 2016, a fact in line with counter-terrorism measures and not with the conduct of a genocidal campaign. Again, stripped of context, the Gambia scatters fragmented allegations throughout its memorial for this location. The resulting picture is confused and certainly not one capable of showing a consistent pattern. In essence, undated allegations of murder, rape, and burning are made, which stem from anonymous, untested, hearsay summaries within various reports. The underlying sources indicate that some of the allegations can be dated to 2016. For the reasons already discussed, no evidential weight can be given to these sources. Mr. President, I note the time. I'm not sure if this would be a convenient moment to take the lunch break.
Yes, thank you. I thank you for your statement. Indeed, before you begin the next section of your presentation, this may be a good time to bring this sitting to a close. The oral proceeding will resume this afternoon at 3 p.m., when Ms. Lowry may continue her presentation. The sitting is closed.